that is true. Except for I'll engage her briefly because I have a written document that is partly collected. So I am going to need to speak with her. I don't think it's not a good recording. That is true. How about a 100-page movie? So much simpler.
For the record, my client is nodding. For the record, my client is nodding. Keep it up.
Michelle, just to let you know, we're waiting for the judge to return to the bench. That must have come,
All rise.
My understanding is that she can hear us now. Ms. Lundgren, can you hear us? Okay, we can't hear her, but I don't see a problem with that because we don't want her to say anything on the record when our attorney's not right here. So that's perfect. We can proceed back on the record. We already had appearances. We have a couple of motions that need to be addressed. I'm going to first address Defendant Kent Vanderwood's motion to allow third-party stenographer to attend and transcribe the preliminary examinations. And I did not receive a response from the Attorney General's office. Did they seek?
We don't object, Your Honor.
No objection to that? Okay, I'll sign that order. And I believe the stenographer is already present, is that correct?
Yes.
Your Honor, if I may?
Yes.
I think there's one open issue on the court reporter transcript, and that is how it can be used afterwards. So it's great that we have a court reporter here. I think there's some purposes. We'll see what's on the transcript closer in time to today's hearing. However, if there's going to be motion practice, which I'm sure there will be, at least for bind over, and I'm not sure the court's timing on that, whether that will be at the end of this group session or at the end of when all defendants have had their exams. But it seems to me that we should be able to use the transcripts that get generated for today and tomorrow for purposes of motion practice down the line.
These transcripts will not be used for motion practice. You need the official court record if you want to do motion practice. And if you want to request an expedited court record transcript at the expedited rate, you can do that. But him bringing his own personal stenographer does not substitute the use of a official court record to be filed with your any motions. So I'm not granting that motion. I'm just allowing him to bring a stenographer to transcribe. My assumption is they want to use that for the purposes of preparing for their own preliminary examination.
Thank you.
Thank you. Okay, there was also a people's motion to quash subpoena or issue a protective order. That was received by the court at 3:30 yesterday.
That is not set for argument today, Your Honor, and the parties are in absolute agreement that the parameters of that can be worked out later. So we would ask the court for purposes of today to disregard that.
Very good, and I think that was mentioned in the motion, considering the fact that the defense is not likely to be calling any witnesses today.
Correct.
Tomorrow.
And the only reason we filed it yesterday was because it would have been due by the 14th. And so any later it would have been untimely.
Thank you.
Thank you.
There's also the people's motion for Assistant Attorney General Aaron Van Langeveld, is that how you say his last name?
Yes, Your Honor.
To remain in the courtroom during the preliminary examination. I received that filing and did not receive any responsive filings from the defense counsel. I see someone pop up, so I guess you want to respond on the record.
Yes, Your Honor. First, can I have a continuing permission to step into the role of the courtroom and put my stuff up here? I don't want to
Put yourself where?
on this bar here.
As long as it doesn't interfere with what he's gotta do, I can't see it anyway, so.
And Your Honor, Ms. Burton did file a response to our motion, so the people did receive that. It was absolutely timely. We've had an opportunity to review it. However, I don't believe any of the other defendants have filed an answer to our motion.
I believe so, Your Honor, but I have a copy here. I mean, I don't expect the court to read it on the bench, but I'm happy to provide it.
Yeah, you can, make your argument now.
If I may have put.
Thank you.
Thank you, and with it being the people's motion, we would ask to make argument prior to Ms. Burton.
Yes, that's completely fine. You can
Okay.
proceed.
Very good, thank you, Your Honor. So the first thing I want to do, and acknowledging that the court is at this time reading Ms. Burton's response, there is something that I want to absolutely address from that response at the outset. So the people's motion asking for their attorney to remain in the courtroom is not, as Ms. Burton has argued, and perhaps others will argue today, a motion for reconsideration or rehearing under MCR 2.119F. That court rule deals with, and I quote, rehearing or reconsideration of the decision on a motion. It appears within the rule that governs motion practice. The defendants here did not file a motion regarding AAG Van Langeveld's situation. Instead, they made an objection. And it was, in fact, the defendants who had control of exactly how this issue would come before the court. And they decided in a manner that appeared, at least to the people, rather coordinated, to object during the preliminary examination rather than file a motion and brief and seek an order ahead of time. So because the defendants did raise this matter as an objection, it's really no different than any other ruling made during the course of a single proceeding, which this court may, of course, correct as new information comes to light and reconsider as the proofs roll in. And we are still here today, Your Honor, in the very same proceeding where that objection was initially made. And that is why it is MCR 6.435 that controls, and the court may reconsider that ruling, just as any other evidentiary ruling that's made in this proceeding. And this isn't even the first time that this has happened. On December 13th and December 14th, this court was asked on many occasions to reconsider previous rulings depending on what the testimony was. And it is no different here. The court is allowed to reconsider an objection that is made within that very same proceeding, and that is what is occurring here today. Now, as to the substance of the motion itself, Your Honor, the people's motion places one matter and one matter alone before this court, and that is whether MRE 615 prohibits sequestering the people's representative, AAG Van Langeveld. MRE 615 is titled Exclusion of Witnesses, and it puts exclusion of witnesses within the court's discretion with the exception of 3 categories, 2 of which are at issue here, and are applicable to all assistant attorney generals who represent the people in this matter as designated by Attorney General Dana Nessel. So first, under Section B, the court cannot exclude an officer or employee of a party which is not a natural person designated as its representative by its attorney. MCR 6.0031 defines party to include the lawyer representing the party. And that is critical for how this component of the rule is interpreted and applied to AAG Van Langeveld. So there are really three parts to that component, Your Honor, and this isn't a hocus pocus thing where we're trying to twist the language of a rule or anything of that nature. We want the court to look at the language of this component and consider how it applies to the people's representative. So first, the party at issue here is the people of the state of Michigan. And collectively as a party, the people of the state of Michigan is not a natural person. And no one can dispute that. We are not a natural person. We represent the people of the state of Michigan, not a single individual. Second, the people of the state of Michigan's attorney in this matter is Attorney General Dana Nessel. And again, no one can dispute that. She is the attorney. Third and last, AAG Van Langeveld is one of the Attorney General's employees or officers. Both of those are true. And she has designated him as one of her representatives in this matter. And again, because party is defined as the court role, as including the lawyer representing the party, there is really no dispute that AAG Van Langeveld cannot be sequestered under Section B of MRE 615. Second, MRE 615C prohibits sequestering AAG Van Langeveld. The court cannot exclude a person who is shown by a party to be essential for the presentation of a party's cause. And of course, it is only a party, whether that is the defense or prosecution, who can decide who is essential for the presentation of their cause. It is not for the other party to weigh in on that inquiry from a factual or even a necessity standpoint. But what I am saying to the court today, as an officer of the court and as a representative for the people, am affirmatively stating for this court that there are 4 lawyers from the Department of Attorney General who are signed to this case as the people's representatives, and each of them are essential to the presentation of the people's cause. AAG Van Langeveld is essential because of his role in the investigation, his familiarity with the case, and his expertise in election law. Because of his expertise, he's uniquely situated to consult with the rest of the team regarding issues of election law as they arise during the testimony. He is absolutely essential from a factual and a strategic standpoint. And while I appreciate, I guess, the implied compliment in Ms. Burton's response that there are 3 talented lawyers who are currently representing the people in this matter, I agree, there are 3 talented lawyers. It is not, the inquiry is not whether we need a 4th. We are not each fungible substitutes for one another, and we each have our own unique roles and skills in this matter. And the inquiry is not also whether the remaining AAGs on the team can consult with a witness or find someone to ask their questions later. We need AAG Van Langeveld in the courtroom to assist us in real time as these issues arise. His absence has already harmed the people's ability to present their cause, and we're asking this court to correct that today because MRE 1615C prohibits his sequestration. Now, as I said earlier, the only motion before the court today deals with MRE 615. However, when we were last here, there appeared to be some sort of implication from the defense that there was something unethical about AAG Van Langeveld serving as a member of the prosecution team while also being a possible witness. And that is absolutely incorrect. And it is not a part of the inquiry under MRE 615. I know the court is still reading Ms. Burton's response. She really doubled down on this, and I don't know if we're going to see that type of argument from the rest of the defendants today, but in doing so, the problem is that she ignored the actual language of Michigan Rules of Professional Conduct 3.7 and ignored the definitions that actually apply to that inquiry as well. She substituted her own definitions, and that's just not how this works. Of course, AAG Van Langeveld is an advocate in this case in the most general sense. And of course, he is also an assistant attorney general, but those are not substitutes for definitions that actually apply. Under MRPC 3.7a, a lawyer shall not act as an advocate at trial. in which the lawyer is likely to be a necessary witness, except where the testimony pertains to an uncontested matter. So just a couple points about that, and then I promise I will sit down. First, we're not at trial yet. Second, it is not just being an advocate, but being an advocate at trial that matters. We are not at trial yet. Being an advocate at trial, according to State Bar Ethics Opinion RI 281, means presenting evidence or argument in court. So from an ethical standpoint, because Van Langeveld is not an advocate at trial at present, and he never will be an advocate at trial, it doesn't even matter what kind of witness he is. He could be a necessary witness. He could be a necessary witness regarding contested matters. He could be a witness. He could be someone who was subpoenaed for any reason or no reason at all. Because it doesn't matter what type of witness he is, he's not an advocate at trial, so it doesn't matter what kind of witness he is, Your Honor. He could be any of those three categories. He could be the most necessary witness on the most contested matter, but because he is not an advocate at trial in this matter, there is no ethical problem with him being on this team. And I know that that's something that the court is familiar with from your experience as an assistant attorney general. You're familiar with the process internally that occurs, the inquiries that occur, and we did share that with the court just for the purpose of being transparent about what our inquiry is. So, serving AG Van Langeveld with a subpoena doesn't matter for purposes of MRE 615 because it doesn't matter what kind of witness he is. He will never be an advocate at trial, so he can ethically be any type of witness at all. So for these reasons, we are asking the court to find under MRE 615B that AG Van Langeveld cannot be sequestered. He is a representative of the people in this matter, and he is also essential to the presentation of the people's cause, so he cannot be sequestered under MRE 615C. Does the court have any questions about our position? I'm also happy to address anything that the court has been thinking about regarding this, or any concerns that the court has.
So it's not the position of the Assistant Attorney General or the Attorney General's office that this advocate or attorney is not a potential witness? You're not
Absolutely not,
conceding
Your
he's a
Honor.
potential
We agree and concede that he is a possible witness. But the thing about MRE 615 is that it assumes that who we're talking about is witnesses. So it's not, it's not a rule that applies if he wasn't a witness, for example. Yes, we agree that he is a possible witness. Now, as we discussed earlier, there is a motion to quash the subpoena pending, but even with that, we're not saying he couldn't ever be a witness or anything. We're just saying the things that were identified as potential topics of testimony are not appropriate. There's no doubt that he was involved in various aspects of the investigation. Those are potential topics of inquiry for him as a witness. And we're also not contesting what his role was on the State Board of Canvassers. He is a possible fact witness for those things, just not in the manner that was identified in the answer that was filed by Ms. Burden. So the court is completely correct. The crux of this is that he's not an advocate at trial, so he can be a witness. And these are no different than the rules that apply to civil attorneys as well. This is an inquiry that comes up, I think, a lot more often when we're talking about potential civil clients. And that's really where the ethics rule, the ethics opinion rather, RI 281 comes from. It was a case dealing with what the parameters of a civil attorney could be when they're also a possible witness to a situation. And so this isn't even an inquiry that is limited to prosecutors. It's something that comes up quite a bit with civil attorneys as well, and they have to examine ethically whether they can be a part of a particular case and what role they can serve in it. So it's not really irregular here or in the civil realm. Attorneys, whether anybody likes it or not, attorneys can serve dual roles as witnesses and attorneys. It's just that their role has to be carefully crafted, which is what the people did here. So, long answer to the court's question, but no, we're not contesting that he's potentially a witness.
Thank you, Mr. Kroger.
Thank you, Judge. My strategy here has changed a little bit because, I guess due to our failure, the court didn't receive the judge's copies, so if the court would bear with me, that was a lot to address. I had hoped to largely rely on my brief. Number one, I would say that there's no question that what is in fact an improperly submitted motion for reconsideration. It's not our job as defense lawyers to telegraph our movements, to ensure that the prosecutor's evidence passes muster that they present in court. The court will recall that the prosecutor submitted for admission a document bearing AAG Langeveld's signature, which is a topic at issue in this case. The objection was made, and the people then made an oral motion. The court heard argument from the prosecutor, and then it heard argument from the defense lawyers, and it made its ruling. So consistent with the rule for motion for reconsideration, an oral motion is a motion. They happen all the time. That's what the people did. They blew its deadline. It should be outright denied as untimely. As it relates to advocates, I have to say, and it's not to be flippant or overly aggressive, but I have to point out so the court isn't, one's not pulled over the court's eyes here. In its principal brief, the state labeled AAG Langeveld, Van Langeveld, as a consultant and a representative, saying therefore that he's outside Rule 615's, or he's included in 615's ability to be included in court, even though he's a witness. In the brief that they filed yesterday, the court said at 3:30, and I'm not faulting the prosecutor. I anticipated a motion sort of like what they filed. I'm not faulting the timing, but I do have to highlight for the court that by nature of the subpoena, AAG Van Langeveld morphed from consultant and advocate back to prosecutor in yesterday's brief. I know the court hasn't had time to read it. So there's no question that he is in fact acting as an assistant attorney general prosecutor in this case. It's not a political consultant. It's not a representative. In fact, the court will recall we stipulated to Agent Schock being the representative, which is commonly understood that the lead investigator or detective or officer in the case for prosecution gets to stay in the courtroom. That everybody knows that. We don't dispute that. The representative has already been assigned. When it comes to essential, Your Honor, actually let me back to 615B. 615B says that the designee is assigned by an attorney, the attorney, which necessarily excludes from being a representative under 615 attorneys. As it relates to being essential, the prosecutor stated that 4 prosecutors are essential to this case. AAG Crino, AAG Logan, AAG Van Langeveld, AAG Hagman Clark. I'll note that AAG Hagman Clark is so essential, she's not in court. I think the same goes for AAG Van Langeveld when it goes to who's essential. The real prosecutors prosecuting the case are at the prosecutor's table, Your Honor. The AAG or the prosecutors cited and referenced a ethics opinion that they attached to their principal brief Your Honor, and I have to note that that opinion, number one, is redacted. I typically wouldn't go after such an opinion in discovery. The people have put it in issue. It's attached to a brief. It's redacted. It deals central to the issue that they're raising. It's my position that the defense is entitled to discovery on that ethics opinion. They need to be ordered to reveal who wrote it. All of the discussions among the Attorney General's office are no longer privileged, is our position. We've briefed this more fully to the court in our response to the motion to quash. Just flagging it for now. And I also have to note, the ethics opinion says, number one, in my read of it, obviously we can all read it for ourselves. My read of it is, number one, AG Van Langeveld can theoretically participate in the investigation. However, he cannot participate in the prosecution. Well, this is the prosecution, Your Honor. And in fact, the state has labeled him a prosecutor in the most recent pleading. The people today declared, yes, he's an advocate, yes, he's a prosecutor, so on and so forth. They're trying to shield themselves behind the prosecutor's immunity and the safeguards that would prevent, generally, a prosecutor from being subpoenaed. I have to state, if you give a fair read to the people's pleadings, Your Honor, it is pretty clear that the people of the state of Michigan, through the Attorney General's office, are violating, or attempting to further violate, their own ethics opinion. That needs to be explored. It's, again, attached to the brief, it's in the pleadings, and I don't know what the remedy for something like that is. I don't think anyone, and I know I certainly have never seen anything like this in a criminal prosecution. Step number one for criminal prosecution, everyone will tell you, don't make yourself a witness in your own case. Why they did this, I think briefing and argument, testimony is going to bear that out, but it's a major problem, and I don't mean to throw, and I'm not trying to throw allegations out unfounded, but there's an inquiry might need to be made about prosecutorial misconduct and what it means for this case.
Okay, well, I actually have a question since you paused there.
Yeah, sure.
Because your office subpoenaed this witness, correct?
Yes, sir.
Okay, and so can you really just touch on why this witness would be a necessary witness?
Yes, Your Honor. So, it's well established that AAG Van Langeveld signed the documents that he signed and engaged in the activity that he did as a member of the State Board of Canvassers. It's very public. A Politico article references him as the lone man that stopped Trump. I think the evidence is going to bear out that Special Agent Schatz, I would say very unusual affidavit with many legal theories and case law citations, I believe, so on and so forth. The entire justification for charging this case was that there was no viable, plausible legal argument that could result in reversal of the official votes. Now, I'm not here to relitigate 2020's election, whatever. We should move on beyond, that piece of it. But the fact of the matter remains, on December 6th, and this is going to come out too, AAG Van Langeveld, AAG Caprino, and Special Agent Schock sat down with a man named Ken Chesbrough, who explained to them for over 4 hours how multiple, not just a recount in Michigan, multiple avenues existed based on federal precedent, based on historical precedent, based on statutes in the federal code, the U.S. Constitution, so on and so forth, that there was in fact the possibility that it could have been reversed up to January 6th. Again, I'm not saying one way or the other what the merits of that happening were, what the practical possibilities or probabilities were, but at base what it comes down to is AAG Van Langeveld put the very legal reason in Agent Schott's, at least that's my theory, affidavit to justify getting this through, so warrants would be issued. And then when he does testify, and again, we'll address in writing the people's motion to quash or for protective order. When he testifies, it's going to come up. What did he think, he being Van Langeveld, who effectively argued with Cheesebro in the interview that, the margin was so big, there wasn't a recount, therefore there's a crime committed, basically, is the gist, and that's what's going to come out. Did Van Langeveld, ultimately where we're going to go, but it'll be in more detail in our briefing, did Van Langeveld understand at the time that he was sitting on the board of state canvassers that if Congress, if a court reported back to him, hey, you got to recertify the election in favor of then President Trump, does he understand that he would have had to sign that, so on and so forth? That's ultimately where we're going. It's not as clear as, oh, he just signed this paper and that's his only role in the case. The other piece of this that the people have really opened up, and I think it's a very unusual hill to die on, why he joined the prosecution, given his very public national attention as it related to Michigan's election, why he joined the prosecution to come after these people. I mean, prosecute grandmas, widows, and grandpas for something that's frankly not a crime. We'll get to that in our briefing as well. That all goes to credibility, not just of AAG Van Langeveld, but of the entire investigative body. The motivations for prosecuting this case, it all ties together. It's all exculpatory, is my view, potentially exculpatory, and the defense is absolutely entitled to all that information. Moreover, the Michigan Rule of Evidence 615 that the state is attempting to rely on gives way to these criminal defendants' statutory and constitutional rights. So to narrow in on a Michigan Rule of Evidence and say, oh, fairness goes out the window, oh, Sixth Amendment to right to confrontation goes out the window, and so does everything every prosecutor who's ever prosecuted knows about prosecution goes out the window because the Michigan Attorney General wants to prosecute these people for something that's political and not a crime. Your Honor, is not constitutional, it's not lawful. Did I answer the court's question? I apologize. I ran through quite a bit.
We went off on a large tangent there, but we hit it in the beginning. Any further argument that you want to provide?
If I may have one moment, Your Honor. Good point from my colleague, Your Honor. This is, the people referenced the civil case. This isn't a civil case, this is a criminal prosecution with a maximum penalty, in theory, of up to 14 years in prison. The defendants, Kathy Burton's liberty is on the line. We're not talking about money here. That makes this case very different. So to say, well, this happens in a civil context all the time, I mean, maybe, maybe not. I don't think any lawyer is putting themselves in a position intentionally where they're going to be a witness in their own case. But even if it were happening in the civil context, Your Honor, it doesn't apply to the criminal context. It's a totally different thing. Every court in Michigan, the U.S. Supreme Court, Sixth Circuit, federal districts, everybody recognizes there's far more care and rigidity in criminal prosecution than there is in a civil prosecution. The other thing to consider is improper vouching. Sequestration is important. He's a fact witness who it's the defense's belief that basically orchestrated the entire erroneous, in my view, legal theory of how this case was even brought. His comments to Mr. Chesborough, I think I'm saying that right, really bear that out. He's, I think, the orchestration of this entire thing. I think he explained it to Agent Schock. And ultimately, when the Attorney General gave her comments publicly, what she was saying is the same thing he's saying. So I think the defense is absolutely entitled to explore that with him on the witness stand and get to the bottom of where did this idea come from? How did you get here, given the political nature, your involvement in the case, so on and so forth? He was the lead investigator.
Okay, and you're addressing the motion to quash, is that what you're addressing?
Yes, sir.
Christina? Okay.
No. I'm
Because
talking.
you're getting into what you want to question him about.
Oh, well, it goes to vouching.
Okay.
Yeah, sure. So keeping him sequestered goes to vouching. It protects from improper vouching, is the point.
Okay, I recognize that, but I want you to address also the rule of evidence, 615B, that states, and again, this is about witnesses. So that rule essentially states that witnesses can't be excluded if they're designated as the representative by its attorney. So I need you to address that.
By its attorney, Your Honor?
Correct.
He is an attorney.
So attorneys can't have attorneys?
Not when they're not a party to the case.
Okay.
Absolutely, and the other, so it is addressed, Your Honor. Agent Schock is the designee. How many designees does the state have? Can all 300 AAGs come in here? I would say no. We stipulated, that's the designee. What they have done is after the fact, after it was exposed that their prosecutor is improperly involved in this case, and he was thrown out of court, they are sequestered. They come back with new ideas as to why he should be here, and frankly, Your Honor, I think it's an ego thing. It's not based in law. The law here that controls is ultimately the defense's right to fairness, justice, Sixth Amendment confrontation, which includes a fair chance of cross-examination. That's the theme
I recognize that.
underlying
I
sequestration.
completely recognize that, which is why I granted the sequestration order from the beginning. But if we identify and we break down this rule that's been presented here on the people's motion, you gotta understand that it states that they can designate him as their representative, correct?
I disagree with that.
The party can't designate him as a representative, because what in this rule tells you who they can or cannot designate as a representative?
The word attorney necessarily excludes.
It says the party's
attorneys.
attorney.
He's a prosecutor.
He's not a prosecutor on this matter.
I can show you the briefing, Your Honor. Yes, he is.
Which briefing?
The one that they filed yesterday. He
I've not
absolutely.
looked at the briefing yet, so that's not at this time before the
Well,
court.
then I would ask that.
But is he filed, is he entered an appearance on this case as the prosecutor?
I think he did when we all stated our appearances on the record. And again, I don't have that transcript, but I believe he did stand up and indicate his appearance as an assistant attorney general on behalf of the people.
Counsel?
I can help here. It doesn't matter one bit. Yes, he is a prosecutor. Yes, he is a consultant. Yes, he is an advocate. Yes, he is an assistant attorney general.
How
All
can he
of
be the
it.
advocate and the attorney?
Well, advocate at trial is defined as someone who presents argument or evidence at trial. So that is a definition that we only care about if we are talking about the ethical inquiry under 3.7, which obviously is not before the court.
Correct.
I already broke down each piece of MRV 615B, and the thing that is really key for how that applies to attorneys is that it doesn't matter that we're all prosecutors. We are still lawyers, and that rule applies to us the same way that it would as anyone else. And the definition that I previously gave for the court under MCR 6.0031 of the definition of party, including the party's attorney. So we are all, as prosecutors, only here at the pleasure of the Attorney General of Michigan. She is the attorney, she is the attorney for the party, she is the representative, and she has designated all of us. So if
But you are the prosecutor on this case.
what does the court mean when the court is asking that
You're
question?
in-
Because I feel like maybe we're creating
You're in
terms.
the court prosecuting the case. Your
I
name is
am-
on the pleadings. when you work as an assistant attorney general, that power is vested to you to prosecute the case.
100%.
So you are vested today to prosecute this case. My question is he prosecuting the case as well?
No,
So that was the question, because did he file an appearance on behalf of the people?
that is great.
And I can go and
No,
check the
it-
record to see.
this is
who-
hold on. This
I'm
is
sorry,
Agent
well,
Shaw.
the
So-
guy was sitting there then, that's what, the guy that was sitting there at the time.
Yes.
That I,
Yeah, like,
Van Langerveld,
Yes.
that I excluded or sequestered under the sequestration
Yes.
order. And there was another lady that was here as well.
Yes, Ms.
Correct.
Lady McClure, that's
Okay.
correct.
And so, they both, I recall, put an appearance on the
Yes.
record when I asked for the prosecution's appearance.
Yes, that's 100% correct. We agree with that. They are all four prosecutors on this case.
Okay, so then my concern then is how can you be a prosecutor in one regard, which means you can stand and place an objection if you like, you can file pleas if you like, but then in the next regard, you become an advocate if it means that you can stay in the courtroom for sequestration.
No, he cannot and is not going to be an advocate at trial, and that's a decision that was made very early on. That doesn't mean that he can't serve as a consultant. That doesn't mean that he can't assist me if I have a question about Michigan election law that requires the expert who's assigned to our team to help me with. That doesn't mean that I cannot ask him a question. That does not mean that he can't be part of things behind the scenes. So the problem with the way that this argument is going so far is that we are blending three things that really should not be blended and cannot be blended in order to reach the correct conclusion.
Well, in order for him to stay in here under this court rule, he has to, or this rule of evidence, he has to be designated as a representative. So I'm trying to understand what category you all put him in, because it's switching.
No, Your Honor, it's not switching, it's all of these things at the same time, okay? I have never been inconsistent, it is all of these things at the same time.
That's a problem though.
Well, it is not a problem under the court rule, Your Honor, under MCR
I think it is.
614-15B.
I think it is a problem.
There is nothing that says that he can't be an attorney and a representative at the same time. I am an attorney and a
Well, it
representative
says
at the same time.
specifically the officer or employee of a party that is not a natural person after being designated by the party's representative by its attorney, which means that its attorney, the party's, you would need to be the party's attorney, which you are on this case. And you designated him as your representative.
I am only an attorney on this case as designated by Attorney General Nessel. So she is the attorney for the people of the state of Michigan on every criminal case that the Attorney General's office appears on, okay?
I recognize that.
I, Ms. Logan, Ms. Hageman Clark, Mr. Van Langerveld, we are all employees or officers of a party as defined by the court rule. So I'm not making up my own language of this or anything, this is what the court rule says. So Attorney General Nessel is the attorney, we are her party, we are her officers or employees, and we have been designated as her representatives in this case, Your Honor. So, that is our position. I respect if the court disagrees with that, but I think it really is important for that component of it, to remember that party is defined as the attorney representing the party, and that is Attorney General Nessel. And
By
also,
and through you.
I'm sorry?
By and through the parties that are here. So
Yes,
you are
because we,
prosecuting, because we're not gonna see Dana Nessel in here on this case, we're gonna see, the people that are sitting here, filing the pleadings, appearing at the court cases and making the argument,
yes,
correct?
the court is absolutely
Any other
correct.
argument?
I need to correct two things. Number one, party is not Dan Nessel, party is the people of the state of Michigan. Your Honor, number two, the people just said, they redefined 3.7 and said that AAG Langeveld is fine as long as he's not presenting an evidence at trial. You know, the definition she said the first go around was presenting evidence in court. The entire reason
We
that
don't
they,
even need to address that because we're not dealing with that right now.
I mean,
And they also said that they decided he's not gonna be an advocate.
He's not an advocate at trial, that's the
But
that matters and it's
But
consistent
we're
with
not
our
even
brief.
addressing that, I'm addressing 615B, that's all.
can I just one,
Only if it
Yes,
addresses
yeah.
615B.
so it does. He is an attorney and advocate at under 615 because he's feeding information she just said to her to make, she might not be the one saying it, but he's speaking through the rest of his co-counsel, which have second chairs in trials happen all the time. That person, if you're, only been a lawyer 2 or 3 years, doesn't talk. They say, hey, ask him this, hey, do this. It's happened in this court.
Your Honor, that has
You're
nothing to
advocating
do with
through
MRA
the-
615B.
through the mouthpiece.
Nothing.
I'd invite the rest to join and.
Really briefly, Mr. Van Langerveld's role has morphed and continues to morph today. So he has 3 roles as I count them today. An attorney, and he stood up and put his name on the record the last time we were here. A witness, and he is a fact witness, a material fact witness, and then now, today, a representative. It appears he was designated as a representative after the fact in order to get him in the courtroom. Those 3 categories are mutually exclusive. So under 615B, an officer or employee of a party, Mr. Van Langerveld is not an officer of the people of the state of Michigan, and I don't even think he's an employee of the people of the state of Michigan. He's an employee of the Attorney General's office. After being designated as the party's representative by its attorney, you can't be both an attorney and a representative and a witness all at the same time. I mean, if we think about this in the most basic of context, if the prosecution has a murder here, and then Mr. Langerveld is a witness to that murder, is he going to prosecute at the exam and then pop up and then provide his testimony? It's gamesmanship, and I'm not even sure why it is a fight that the Attorney General's office wants to have. Every minute that he would be in this courtroom diminishes his credibility as a witness for the government. So I join in the comments and the objections by Mr. Cover and Mr. Danini, and he should not be in this courtroom.
Thank you. I'm done taking argument on this issue because it's almost 10 o'clock and we've not proceeded on this exam. I read the briefs except for the response from Bearden, but you've given your arguments on the record. I agree that Mr. say his name again?
Van Langerveld. Your
Van
Honor.
Langerveld's role keeps switching at the convenience of the people, and I have a problem with it. I think it's grossly prejudicial to the case to have this person who is, I believe, a essential witness. He was on the board of canvassers. He's the person that helped vote to certify this election, which is the issue at stake here. And he's sitting here. He's obviously been a part of the investigation, and that was up to the prosecution to decide if they wanted to include him on that after they've gotten their ethics report. The ethics report even tells you, I don't see a problem with him being a part of the investigation, but there could be an issue with him being a part of at the time of trial. I think that he needs to be sequestered. I think the sequestration ruling was appropriate. I think that to use the defense counsel's word, this is some gamemanship by the part of the Attorney General's office, because we can't have a role switching and we can't have all 3 roles. You're not going to be an advocate when it's appropriate. You're not going to be a representative of the Attorney General when it's appropriate, and you're not going to be an essential witness all at the same time. And so, and I think that the Attorney General's office perceived this to be an issue in advance, and things have been switching at the convenience in order to try to figure out how to get him in here. My sequestration ruling stands. I'm going to deny the motion to quash the subpoena because I think he's an essential witness. They have every right to call an essential witness to submit to their defense. I also agree that you wouldn't want to have a witness in here that could take away from your credibility. And I get that he may provide some valuable information and knowledge as it relates to election because of the nature of the background that he has. He sat on the board of canvassers. So I recognize, again, as Mr. Kroger put in at the time of his motion, I too worked at the Office of the Attorney General. I was in civil litigation, employment, and elections. So I understand that there are certain individuals in that department that have a specific knowledge base that can assist in this case. It's unfortunate that the Attorney General chose this person to be a part of the team, understanding that there could be an issue as it proceeded or as it progressed in the courts. At this point, that's something they're going to have to live with because my ruling is going to stand. So any additional matters that we need to address before we call the next witness?
Thank you, Your Honor. Nothing more than that.
Thank you, Your Honor. This could be a an issue that, could be on us. We filed a motion in limine. If the court did not receive that copy,
I do have your motion in limine. You want to prohibit some information that they're gonna bring in?
No, Your Honor, we wanna, get the admissibility of the information we wanna bring in.
Well, we're not even there right now. We're really
Well,
at.
I'm sorry, Judge, go ahead.
I want to get them to post their proofs. That's my goal.
Just flagging it for the court, Your Honor. It
Yeah,
will
I
come-
have it right here.
it will come up
I
with-
was only addressing anything that would prevent them from being able to post their proofs, and then we can deal with, and I can only imagine that new motions will arise between now and then, because that's been the nature of this case, and we can address that before the defense, makes any of their, I didn't anticipate the defense proceeding with any proofs today or tomorrow.
No, Your Honor, but it will come up in Agent Schott's testimony,
Okay.
whenever that is. Just
Okay.
flagging it for the court. Thank you, Your Honor.
Sounds good. Mr. Silverman?
And one's personal, 90 seconds, nature. And the other one deals with the case. I have prepared, Dwayne Silverthorne on the record, on behalf of Michelle.
I did review it, I just didn't sign it.
Well, it's not an order, it's just an affidavit
Correct.
that I would sign on her behalf.
Oh, okay,
Because I
you
think
wanna
it's
put on the
just-
record that you got her
I think that it probably would be prudent.
Okay, you can question your client. If she can,
Michelle,
she can nod.
Michelle, can you hear me?
Nod your head if you can hear him.
Okay. We discussed earlier, I read you the affidavit in which you're going to waive your right to personally appear, is that correct?
Nod your head if that's correct.
Okay, and you realize that that causes maybe a little bit of difficulty in you conferring with me, correct? Okay, and you've agreed that you're gonna waive any objection that that might raise by having us physically separated, correct? Okay, and you also realize that this only applies to today's hearing and to tomorrow's hearing, and it's based on your injury that leaves you housebound, correct? I haven't read the full affidavit, but I did read the full
Okay,
affidavit.
for the record, Ms. Lundgren did nod her head to each question that was posed to her.
Finally, may I sign your name on, my name on your behalf?
For the
Thank you.
record, Ms. Lundgren is nodding her head. Any additional inquiries?
No, and
Okay,
then the
we'll
other,
take a recess
thank you,
so
guys.
that you can hear the picture. 5 minutes.
is.
They blew the breaker. We got called, the building have to come up there. We don't have, there's a pipe that burst, so we have no heat. So they are running space heaters, that's why it's warm. So it's blowing a breaker. It's warm here, it's freezing in there. So we have to, call, have the, yeah, they'll bring the building guy up here, tell him it's urgent.
This is my fault.
I'm sorry?
It's my fault.
No, it's not.
No, it is, cause I said I hope we wrapped a little early today. It's my fault. It's my fault.
I think we all saw that.
This definitely happened yesterday.
I did, I'm sorry. It's.
But you're torn because you wanna speak it into existence, but then you don't know if it's
I was
temporary.
I mean, but wrapping early is really within your control though. Really?
I don't know if it's within our control.
No, please.
I was trying to manifest.
Manifesting school just didn't work this time.
I've been fairly succinct, I'll tell you, you know what I mean, which is like out of the norm for me.
Oh, okay.
No, I work for a freelance court reporting firm. So, you know, this is only really like the third time I've done like a trial, like courtroom work, and only it's just depositions, so I'm somewhere different every day, mostly lawyers' offices. But great job. Flexible and, I mean,
Oh, you can turn it on.
because
You
you're
know.
an independent contractor, you know, you can look a little, it's much, but I mean, like, I would say 50 to 200,000, like anything within there, you know what I mean? So,
2 years.
2 years.
Like, where do you go to that?
Well, I went to a school that is now closed, and that's part of the problem, because there's not enough people to support an independent school, but, Macomb Community College, and then there's some like online school type stuff, so.
Pass that information along to my kids.
Oh my God, yeah,
Yeah.
it's a great.
All right.
So I just do civil stuff, depositions is all civil law. And now all the courtrooms used to have a court reporter here, but now they just video system.
Federal court still has one though.
Yeah, I mean some. Is that what she No, she's like a clerk. You know. I just don't think people know.
Yep, it's coming back up now.
I thought say what I do and they're like, oh, you're that lady, you know. Whatever. So I'm like, I want to get to Hollywood and be the official court reporter for TVs and movies because the way they portray it is just ridiculous.
Yeah, it is.
She's gonna re-log on.
They're just like,
Oh, she is?
and I'm like,
Oh, okay.
But see, if I were to do that, I would do it for all the trials. My problem is I'd get so engrossed in hearing the testimony, I'd probably forget to do the job.
Yeah, it just kind of becomes second nature, you know. In for your ears, out for your We're state certified at 220.
220 words a minute?
225.
Like Toledo.
It's just so different. It's totally different than typing.
My initial didn't even teach typing. I don't even, I love it.
I look too. I'm not a great actual typist. I type with like 3 fingers.
We had to take typing.
We took it. I just
And those
did
old
it.
IBM Electrics.
Big
No,
floppy
IBM
disk.
Selectrics, is that what they were called?
Big giant floppy disk.
You are in the meeting now.
Yeah, because they won't be arguing.
Okay, Ms. Lundgren, if you can hear us, please nod your head. Okay, excellent. Okay, back on the record, in the matters of people of the state of Michigan versus Bearden, Fascinello, Haggard, Henry, Lundgren, and Maddock. Are we ready to call witnesses?
Yes, Your Honor, the people's first witness is a virtual witness, maybe in the court's waiting room, Ms. Miriam Vincent.
Miriam Vincent, can you hear us?
Yes, I can.
Okay, can you please start your video? Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Okay, I'm gonna give you a couple of rules, you can put your hand down. We need all of your responses to be verbal, so we need, no head nods and head shakes. We also need yes and no, if it's a yes or no question. You can't do mm-hmm and uh-huh, because that's difficult to put into the record. There's also gonna be a bit of a delay and some feedback, obviously, because you're appearing virtually. So if you hear an objection, I need you to stop speaking immediately, allow us to make ruling on that objection, and then I will tell you if you can give that response or not, okay?
Okay.
Okay, please state your first and last name and then spell both.
Miriam Vincent. M as in Mary. I-R-I-A-M as in Mary. V as in Victor. I-N-C-E-N-T.
Thank you. Counsel, you can proceed.
Good morning.
Good morning.
Ms. Vincent, can you please tell us, where do you work, ma'am?
I work at the Office of the Federal Register, part of the National Archives and Records Administration in Washington, D.C.
And what is your current capacity?
I am the Acting Director of Legal Affairs and Policy in the office.
Could you tell us some of your duties as the Acting Director of Legal Affairs and Policy?
The Legal Affairs Division offers legal support and advice for publication of all the documents that come in for publication in the Federal Register, which is somewhere between 25 and 32,000 documents a year. We publish on behalf of over 300 federal entities, the departments, offices, and agencies throughout the federal government. And then we codify a fair number of those in the Code of Federal Regulations. We provide assistance for agencies in drafting and in making rulemaking decisions, not their policy decisions, but in how they can comply with our publication regulations. We offer training to agencies, and then we also do training for our staff. And then we're also responsible for administering the Electoral College every 4 years and administering any proposed constitutional amendments if they are passed as a joint resolution through Congress.
And part of the documents that you receive, are some of those documents election related?
Yes, so as part of our duties, for administering the electoral college, we act as a trusted liaison between the states and the Congress. But as part of our delegated duties from the archivist, we are responsible for accepting the certificates of ascertainment and the certificates of vote that are prepared by the states as part of the process of electing the president. They prepare those documents. The certificates of ascertainment come to us directly before the meeting of the electors as the vehicle that appoints the electors. After the meeting of the electors, which is where the electors vote for president, the certificate of vote is then paired with additional original copies of the certificate of ascertainment. One set of paired documents goes directly to Congress, to the president of the Senate's office, and then 2 sets of those come directly to the archivist, to our office on behalf of the archivist. We maintain one of those sets permanently in the National Archives. They're available for public inspection physically for 1 year. They're available online indefinitely. And then the second set we have as a backup in case the congressional set does not arrive or does not arrive on time.
And this was the procedure that was in place and followed in 2020 during the presidential election?
Yes.
Now, following the 2020 presidential election, did the archivists or the National Archives receive certificates of ascertainment and certificates of votes for all 50 states?
All 50 states and the District of Columbia.
And were there instances where additional certificates of votes were received by the National Archives?
Yeah, there was material that purported to be a certificate of vote that was received from non-official, which would be from non-state sources, yes.
And the non-official documents, are those preserved as well as the official documents?
Yes, they are.
And how are those preserved?
So those are considered part of the administrative record, so part of the records of the Office of the Federal Register. They are not considered part of the presidential record series. They are not considered actual certificates of vote because they are not from the actual state, but they were received and therefore created as part of the Electoral College process. They are part of the historical record of what happened. So they were made part of the records of the Office of the Federal Register, and they will be eventually archived as permanent records of our office.
Now, I previously provided to you what has been marked as People's Proposed Exhibit 12. Have you had an opportunity to review that document?
Yes, I have.
And did you recognize that document?
Yes, I did.
Could you tell us what that is?
That is material that I provided to your office that I had notarized at the National Archives and Records Administration. It's the physical copies of what we received, and as in early January, from it was the postmark was the Michigan Republican Party.
Your Honor, do I have authority to share my screen?
Okay, you should have the authority.
Ms. Vincent, are you able to see my screen? It should be black.
Yes, I see a black screen.
Now, can you see, what is currently displayed, People's Proposed Exhibit 12? The first page?
Yes,
And is
yes,
that the first page of the document that you received and that you provided to the Department of the Michigan Attorney General?
yes,
And you stated that People's Proposed Exhibit 12 were the documents that were received by the National Archives purportedly coming from the Michigan Republican Party?
that is correct, yes.
Your Honor, this has been previously shown to most of defense counsel. I think there were a couple counsel who were not, here. But the people would move to admit People's Proposed Exhibit 12.
Any objections to People's 12?
No, Your Honor, thank you.
None from this argument. No, Your Honor. None from this one, Your Honor.
None, Your Honor.
Okay, without objection, People's 12 is admitted.
Permission to publish?
Yes.
Your Honor, at this time, the people will pass the witness.
Thank you, Your Honor. Ms. Vincent, my name is Mary Chartier, and I have just a few questions for you today. Following up on something you said, you indicated that the document that you just reviewed was, the postmark was the Michigan Republican Party. Did I hear that correctly?
The return address,
Okay, terrific. And someone just hand wrote that in, correct?
that is correct.
Now, you talked about two documents, one being the certificate of ascertainment and one being the certificate of votes, and those are paired up?
That is correct.
The certificate of ascertainment comes from, you indicated, a state source. Is that accurate?
Yes, it is.
How do you know it comes from a state source?
The certificate of ascertainment is required to have a state seal and to be signed by the governor of the state.
And does it come just
It
through,
is.
oh, I'm sorry, go ahead, ma'am.
And then it is delivered, in 2012, it was, the requirement was for registered mail. But we didn't, the National Archives had no enforcement authority, so we did not require that it come in any particular, by any particular means, other than we could track the source. So, the state, we have contacts in each state office, and they would provide us the tracking information for each package that they would send us. And so we would be able to track it and see the chain of custody essentially from their office to when it was delivered to us, when we received it.
So how many certificates of ascertainment did you receive from Michigan for 2020? And when I say you, I mean the entity you work for, not you personally.
Right. So I can check. We received at least one original. I don't remember if we had one original and 2 certified copies, or if we had 3 originals that we received in advance of the meeting of the electors. The states have the option of either one of those in 2020. And then following the meeting of the electors, we had another 2 certificates of ascertainment that were then paired with the certificate of vote.
All listing, I wanna be clear, the Democratic electors?
It listed all of the potential electors from all of the parties, and then naming the Democratic electors as those who had been appointed.
Terrific, so that clarifies my question. So you received a certificate of ascertainment listing the Democratic appointed electors from a state source, correct?
Yes,
And you're able to track it, so if I send in a certificate of ascertainment saying I'm an elector from my home address, you would know that was faulty or flawed, correct? Because I'm not a state official.
if we received a package that had a postmark that was other, or that had a return address that was other than a state office, we would question it. We would then have to verify other aspects of the actual certificate. Because, again, you would have to have the state seal and the actual signature of the governor.
And so the only certificates of ascertainment you received in 2020 for Michigan listed the Democratic electors as being appointed, correct?
Correct.
Now then that certificate of ascertainment that you received is matched up with a certificate of votes, correct?
Yes.
Is it fair to say that you need both of those documents, the certificate of ascertainment and the certificate of votes, for it to be valid?
That's the statutory requirement, yes.
In this case, the document you received regarding Republican electors, you did not get a certificate of ascertainment for, correct?
Correct.
And the signature page that has the names affixed to it, you have no idea what any of the electors were told before those signatures were affixed to that page, correct?
Correct.
And you don't know who sent that document in, right?
No, we have the return address on the envelope.
But you don't know who wrote it, correct?
Correct.
And you don't know what the plan was for that document when signatures were being affixed to it, correct?
Correct.
So other than receiving that document, you can't tell us anything about its creation, right?
Correct.
Or anyone's intent when they affix their signature to the signature page.
Correct.
Nothing else, ma'am, thank you.
Good morning, Ms. Vincent. My name is George Danini. I'm an attorney for Ms. Kathleen Burton. Okay, ma'am, can you hear me?
I can, yes, thank you.
Okay, great. So you mentioned your title is Acting Director of Legal Affairs and Policy. Did I get that right?
Yeah.
When did you come into that position?
I have been in the acting position since the end of June.
June of 2023?
June of 2023, yes.
Okay. And did you replace Ms. Katerina Horska as the Director of Legal Affairs
Yeah.
and Policy?
I did.
Okay. And Ms. Horska was in the Director position in the early 2021 time period?
She was.
Okay. Now, you said that this document that you talked about in People's Exhibit 12 was received in early January, is that right?
That is correct.
In fact, was it received on January 8th of 2021?
Yes, it was.
Okay, that's 2 days after Vice President Pence counted the electoral votes, is that right?
Yes,
Okay. Now you said that one of the duty, you guys do a lot there at the National Archives, but one is for administering the Electoral College every 4 years, correct?
yes,
And you use the word, you're the trusted liaison between the states and Congress, right?
yes.
What does it mean to be the trusted liaison? Tell us about that governmental function that the National Archives serves.
So during the lead up to and following the general election, there are times when sometimes individual states, sometimes as a group, states have questions about procedural issues related to the Electoral College. And we serve as a clearinghouse, if you will, for their questions. We take their questions and we pass them along to certain contacts in Congress, in the Secretary of the Senate's office and in the Clerk of the House. They, along with their colleagues in the parliamentarians' offices in both chambers, will answer the questions when we take the answers back to the states. For example, in 2020, a number of questions arose related to COVID, how they could respond to COVID and hold the meeting of the electors and do different things, what things were possible, could be possible, and wanted congressional approval before they did anything, to ensure that all the votes were still procedurally correct and would still be counted. We don't interpret statute, we don't answer questions, but we serve as that conduit between the state governments and Congress, and serve as responding with a single voice, essentially.
Okay, and that's fair. And so all of that is designed to ensure that the electoral votes that are coming from the states, the individual states and the District of Columbia, are appropriate, right?
Yes.
And then it's
That
your,
there are as,
sorry, go ahead, please, finish your.
that there are as few hiccups as possible.
Understood. And then you at the National Archives do all that legwork, you collect these documents, and then you present them to the United States Senate, correct?
Not quite.
Okay, tell me how
We
long.
only present them to the Senate if the Senate does not receive their copy.
All right, fair enough.
So the states send directly to Congress as well as to us, and we have a backup in case Congress does not get their set.
Okay, because you said on direct testimony something about, I wrote down the pairs of documents, so the certificate of ascertainment and the certificate of votes, I believe was what you were talking about, goes from the National Archives to the Congress and the President of the Senate. Did I get that testimony wrong?
Yes.
I got it wrong?
So there are six sets prepared in total at the meeting of the electors. One goes directly to the Secretary of the Senate. Two come to the National Archives. One of those two serves as a backup to the set that goes directly to the Secretary of the Senate. Two pairs stay in the state. One of those two is a backup in case there's a problem with either the set that goes to the Senate or the set that goes to the archivist. And the sixth pair goes to the federal district judge in the federal circuit where the electors meet. And the only purpose of that set is a backup in case something happens to either the congressional set or the archivist set.
Okay, so six are prepared. 6 certificates of ascertainment, 6 certificates of votes, and you at the National Archives get 2 of those. Is that your testimony?
Correct.
Okay.
Yes.
All right, and then, and I don't mean to minimize your role in the presidential election, I think it's a very important one, but essentially, just to try to distill that down, you're the backup and you're the historian.
Right. We have a ministerial role. We are paper pushers. That is what we are.
Okay, but I think it's more than that because you maintain the Electoral College website, right?
We do.
That's important?
Yes.
Okay. And you are doing certain things, and I'm going to get to it, the certificate of ascertainment, to ensure its validity and accuracy. Fair?
Yes.
I mean, you talked about how the National Archives has contacts at each of the states' governor's office to ensure, I believe you used the word chain of custody.
That is correct.
Because you want to make sure that what you're receiving from each of the states is the valid document. Fair?
Correct.
Okay, so let's talk about the certificate of ascertainment, and let's focus you on the state of Michigan for the 2020 election. All right?
Okay.
Okay, you said that the certificate of ascertainment comes directly from the governor of the state of Michigan, right?
It is signed by the governor. Sometimes it comes from the governor's office, sometimes the governor gives it to the Secretary of State's office. But it's one of those 2 offices that sends it.
All right.
I can look at my records and tell you which office sent it from Michigan, if you like.
Well, let's do it this way, because I don't know what you're looking at. So it either came from Governor Whitner's office or Jocelyn Benson's office, correct?
Correct.
And did the National Archives confirm that that package was coming from those one or the other of those sources in 2021? Or excuse me, in 2020?
In 2020, yes.
Okay, and so that happened, yes?
Yes, we get tracking information from all the states.
When did the certificate of ascertainment from the state of Michigan arrive at the National Archives?
I have a document on my computer. I would have to look up the specific date. It arrived before the meeting of the electors in early December.
Okay, so it certainly arrived before December 14, 2020.
Correct.
Does the court have a problem with the witness looking at her computer to find out the date? I think it's useful to have the date.
I have no problem with the refreshing of recollection.
Okay. Ma'am, go ahead. I'd like to know the date that the certificate of ascertainment from Michigan arrived.
November 25th.
Okay. So on November 25th, 2020, the National Archives received that certificate of ascertainment from either Governor Whitmer or Jocelyn Benson, right?
Correct.
Okay. And what is the importance of the certificate of ascertainment from your perspective?
The certificate of ascertainment lists the names of those individuals who can then vote, that is, sign the certificate of vote at the meeting of the electors.
Okay. And if a certificate of ascertainment does not accompany a certificate of votes, what is the legal significance of the certificate of votes from your perspective?
That is not a legally sufficient certificate under the statute.
And you mentioned that before, that the pairing of the certificate of ascertainment and the certificate of votes, you said is a, quote, statutory requirement. Can you expand? Is that federal? What are we talking about there?
That is a federal statutory requirement under 3 USC.
Okay. So a certificate of votes that is unaccompanied by a certificate of ascertainment is meaningless, correct?
Yes.
Now, you provided some testimony about the, I believe I'm going to use your words, the purported COV from non-official and non-state sources. Is that your testimony?
Yeah.
Okay. And that is part of, I believe it was the exhibit 12. Is that right?
Yes.
Okay. Now, you said that that was part of the administrative record, right?
Yes.
But it's not part of the Electoral College website. Is that fair?
Correct.
So,
It's not right. It's not on the results page.
right. So the official document that was used for purposes of the 2020 presidency, that's what goes on the Electoral College website, right?
Yes.
And for the state of Michigan, that would have been the certificate of votes and the certificate of ascertainment received from the state of Michigan. Fair?
Correct.
Now, were you actually at the National Archives for the 2020 presidential election, just in a different role?
Yeah.
Okay, great. So do you mentioned something about the gold seal. Did I hear your testimony correctly?
The state seal, yes.
State seal. Is the state seal affixed to the certificate of votes and the certificate of ascertainment?
No, just the certificate of ascertainment. It can be affixed to the certificate of vote. That is not a requirement.
Okay. Are you aware that the Michigan certificate of votes for the 2020 election for the Democratic side, which is in this case People's Exhibit 4, did bear the gold seal of the state of Michigan?
I would have to look at it again. Every state does something different, so I don't recall what every state does.
Okay. Are there any other, let's start with the certificate of ascertainment. Are there any other hallmarks of, I guess I'll call it authenticity, beyond the gold seal of the state that tells you that the certificate of ascertainment is authentic?
So it has to be signed by the governor, or in the case of the District of Columbia, the mayor. And it has to carry the state seal or the seal of the District of Columbia.
Okay, so
It has to have,
no,
Go
I'm
ahead.
sorry, I interrupted. So I'm sorry, state seal or the district
Mhm.
seal, and the governor's signature or the mayor of DC. Go on, I interrupted you.
right. And those are original signatures. They're not auto pen or other type of image signatures. An original pen and ink signature. They have to contain the names of all nominated electors from all political parties with candidates on the ballot. They have to contain the total number of votes each candidate received from the election. And they have to clearly indicate the names of the individuals who were appointed as electors.
Okay. And why is that, why are those requirements, in particular the state seal of Michigan, the governor's signature, and that it be an actual signature and not some electronic signature? Why are those hallmarks required?
So all of those elements are part of the statutory requirements in 3 U.S.C. Chapter 1, which is the Electoral Count Act, both before and after it was amended by the Electoral Count Reform Act in 2022. The requirement for the pen and ink signature is the congressional interpretation of that act. That is not a plain language requirement of the act. The signature requirement is in the act. Congress has determined that they will not accept an auto pen or an image of the signature. They require a pen and ink signature.
Okay. And now just turning to the certificate of votes, what are the requirements for a certificate of votes?
There are fewer requirements for those. The first is that they are paired with the certificate of ascertainment. The paired set of certificates are then enclosed in an envelope that are signed or certified by the electors as being the complete and official vote total. The certificate of vote themselves must be signed by all of the electors voting. They must contain a separate tally of votes for the president and for the vice president. And I think that's it. Then Congress has required two other elements to ensure that there are no problems. One is that under the electors' signatures, that the states have included the names of the electors. So, because a lot of times elector signatures are not easily legible. The second requirement is that if an elector chooses to vote for a write-in candidate at the meeting of the electors, that the elector provide the state of residence of that write-in candidate to satisfy constitutional requirements. And the third, which is an implied requirement, is that if the state is, or if there are any replacement electors required at the meeting of the electors, that adequate documentation is provided along with the certificates.
Okay, So it sounds like a whole host of requirements and checks and balances that are publicly available and pursuant to federal law and congressional rules.
Yes,
So everybody knows what needs to be done to submit an appropriate electoral vote to the National Archives, fair?
yes,
Okay. And you mentioned that when the certificate of votes is sent into the National Archive, it is paired with the certificate of ascertainment by the electors. Is that right?
yes,
And those two documents are required to travel from the states to the National Archives.
yes.
So if that doesn't happen, then a single certificate of votes is of no consequence.
It's not a legally sufficient certificate of vote.
Right. And then, as an even further check and balance, I think it's clear, but you've got the certificate of votes and the certificate of ascertainment coming from the state, and then you already have the certificate of ascertainment. You testified by November 25th, I think you said,
Yes.
directly from the governor, right?
Correct.
So not only is the certificate of ascertainment and the certificate of votes going to match up with names and votes and numbers, etc., right?
Yes,
But you can see the certificate of ascertainment from the governor and that same document that comes from the electors.
correct.
And if that doesn't match up, it's not going up to the vice or to the president of the Senate. Fair?
You're right. Or the state has to provide adequate documentation to show why it's a different document.
Right. And you said you have sources in each and every state, so you pick up the phone or send an email or communicate however else and get it right. Fair?
Correct. Correct.
Okay. Give me one moment. Okay. No further questions.
Any other questions now?
I have no questions, John.
So, are you got a question?
I was gonna go last, but yeah.
Oh, okay. If you're gonna go last, there's one more.
Okay.
Mary Ann Henry has no questions.
I'm not an election attorney like a lot of my colleagues here, so this pairing up of the certificate of ascertainment and the certificate of vote, pairing up could just mean that the two documents have to be together, correct?
Correct.
But pairing up has a greater meaning, doesn't it? You match the names on the certificate of payment with the certificate of vote, correct?
When they come in, yeah.
Okay. And the certificate of payment can precede the certificate of vote by a month and a half or more, can't it? Well, let me,
Yes,
I'll adjust that question. You receive you're supposed to receive the certificate of attainment first?
Under the 2020 statute, the only requirement was that the certificate of ascertainment be issued before the meeting of the elector.
Okay.
Most of the time we received it in advance. Sometimes it was issued a day or two before, so that we did not actually have it before the meeting. We received all of them at the same time.
But you agree that it appears that the creation of the certificate of ascertainment well precedes, obviously, the certificate of vote, because both got to be tallied, right?
Correct.
Okay. And things happen to people over time, such as death and illness, correct?
Correct.
Is there a procedure for substituting an elector so that you can still submit the certificate of ascertainment and the certificate of vote?
Each state has its own process, its own procedural requirements for a substitution of electors at the meeting of the electors. I don't know what those are, but each state has its own process. And then as long as the documentation is provided as part of that package with the pairing, then that is adequate for both the archives and for Congress.
So if you received a certificate of ascertainment and a certificate of votes in which you didn't receive the documentation explaining a possible difference in names of electors, then that would be invalid, correct?
That raises questions. We call the state, and then the state provides the documentation.
Thank you.
Any other questions? Redirect.
None, Your Honor, thank you.
Okay, may this witness be excused?
Yes, please.
Okay, Ms. Vincent, you may be excused. I am going to advise you, however, not that I think this is an issue, but there is a sequestration order, so that means you're not to have discussion about your testimony with any other witness, okay?
I agree, Your Honor. Thank you.
Thank you, have a good one.
You too. Bye.
Call your next witness.
Your Honor, the people's next witness is Dan Schrader, who I believe is in the waiting room.
Okay, so Dan Schrader's present. I also see a Vivian Rivera, Schrader's counsel. Counsel, I need you to unmute and place your appearance on the record.
Vivian Rivera, Senate Legal Office Counsel, on behalf of Daniel Schrader.
Thank you, and I'm assuming you are right next to him, so I'm gonna mute you back and then unmute him. Okay, Mr. Schrader, please you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Okay, counsel, you can proceed.
Good morning, sir.
Good morning.
In 2020 through 2021, could you tell us where you worked, sir?
I was the general counsel to the Secretary of the United States Senate.
And could you tell us some of your duties as the general counsel for the office of the Secretary of the Senate?
Sure, I had a number of responsibilities in my portfolio, particularly advising the Secretary of the Senate, as well as all of our multiple department heads on any issues regarding compliance, ethics. I reviewed contracts, and I generally supported the administration tasks that the Secretary was responsible for in any way I could, responsible for continuity of government. I was one of the people who led the efforts on obtaining election certificates for Senate elections and electoral college certificates.
Now, specifically referring to your duties as it related to presidential elections, you said you handled electoral college certificates?
Yeah, I kind of led the efforts to keep track of making sure that we received all of the certificates. I worked with either NARA or the states to, NARA being National Archives and Records Administration, either NARA or the states to make sure we received sufficient certificates. I worked with the parliamentarians of the Senate to ensure that they thought the certificates were sufficient for the Senate's purposes.
And you did this regarding the 2020 presidential election?
I did. That was my second run, 2016 as well as 2020.
And as it related to the 2020 presidential election, what type of documents would you expect to receive from the states and District of Columbia?
Well, the Senate, through the President of the Senate, and then they're turned over to the custody of the Secretary, who's the custodian of Senate records. So, President of the Senate receives what we call certificates of vote, which are also commonly called electoral college ballots, and the documents that are attached with those come into the Senate, and that's what we need to receive. Yeah.
Now, for the 2020 presidential election, did you receive a certificate of ascertainment from the state of Michigan?
Yes, the certificates of ascertainment that we receive are first and foremost attached to the certificates of vote. Those are the ones we receive directly from the state. We also, in effect, receive all of these certificates from NARA through their making of them public and then through our communications as well. So yes, we did receive a certificate of ascertainment for the state of Michigan, for every state and the District of Columbia.
Okay. And if I'm understanding your previous answer correctly, your certificate of ascertainment for the state of Michigan came accompanied with the certificate of votes. Is that correct?
That is the way that the principal way that we directly receive it from the state.
Now, you were previously provided a copy of People's Exhibit 4, which has been previously admitted. Do you recall reviewing that document?
I believe so. Can you tell me which exhibit that was? I don't have the numbers on them. My apologies.
I think I can do one better.
Maybe with the email. Yes, I see that.
Alright, Mr. Schwager, are you able to see my screen?
I am, yeah.
For purposes of the record, the people are displaying what has already been admitted, People's Exhibit 4. Do you recognize that document, sir?
I do.
And what is that?
That's what we would call the certificate of votes for the state of Michigan.
Now, I previously provided to you a copy of People's Proposed Exhibit 13. Do you have a copy of that with you?
I believe so. Again, what I have is not numbered. So, yes, I do have that. Sorry, we do have a number.
Do you recognize that document, sir?
I do.
And what is that?
That appears to be the certificate of ascertainment or the amended certificate of ascertainment from the state of Michigan.
Is the copy that you have of Proposed 13 a total of 6 pages?
Yes, it is.
And does it contain both the amended certificate as well as the original certificate of ascertainment for the state of Michigan for the 2020 presidential election?
Yes, it does.
And would this have been a document that you would have received in conjunction with People's Exhibit 3?
Yes, potentially at 2 different
Four,
times. But
sorry.
yes.
Exhibit 4.
Yeah.
Yes. People would move to admit People's Proposed Exhibit 13.
No objection from the board.
No objection.
No objection from Ms. Henry.
No objection. No objection.
People's 13 is admitted.
Permission to publish to the court?
Yes, please.
No. Now, Mr. Schrager, did you receive any other documents purportedly from the state of Michigan during the 2020 presidential election?
We did receive documents purported to be from a slate of electors claiming to be the duly elected and qualified electors of the state of Michigan. That was different.
I believe you said it was different.
Different from the ones that you put us, yes. Different from the actual duly elected and qualified electors.
Now, how were you able to determine that additional certificate of votes was not from the duly elected electors for the state of Michigan?
There are a number of ways, but principally it didn't match the certificates of ascertainment that were signed and sealed by the state officials, by the governor and the secretary of state. Also, all of this happens out in public, and so, you know, the counts, the state publicizes all of the results and the counts, and the governor and the secretary of state announce what they do, and we, you know, see if there's any, you know, if that is all consistent, and then we receive a certificate of votes that matches the certificate of ascertainment, both the one that is attached to the certificates of vote, and we compare it to the one that was sent to the National Archives, the Archivist of the United States, and if all of that matches up and is consistent, then it appears proper on its face.
Now, you were previously provided a copy of People's Proposed Exhibit 14. Do you have that copy in front of you?
I do.
Do you recognize that document?
I do.
And what is that, sir?
This appears to be what we call the purported certificates of vote, certificate of vote, or the package. That's what also referred to it in other ways as well.
And was this document received by the Office of the Secretary of the Senate during the 2020 presidential election?
Yeah, during the course of it, it was received by the Senate. First through the Senate mailroom to the President of the Senate, and then into the custody of the Secretary of the Senate.
And were you able to compare this document to the certificate of ascertainment to determine whether or not it was what it purported to be?
Yes.
And
yes, we could tell that it was not an actual or an authorized certificate of votes. It was not an authorized certificate of votes. It was a fake.
And at this time, the people would move to admit People's Proposed Exhibit 14.
Any objection?
No objections from Ms. Bird.
No objection.
Submitted without objection.
Permission to publish to the board?
Yes.
Well, Mr. Schrager, was the state of Michigan the only state during the 2020 election or during the processing of the 2020 presidential votes where you received slates of electors that could not be verified?
Yeah, that were false. Yes, there were a number of other states.
Now, even though Exhibit 14 could not be verified as the official certificate of votes, what do you do with that document, sir?
Well, it was sent in as part of the process. It becomes a record of the Senate, even if it's not what it purports to be, it was archived as a record of the Senate.
Thank you. We will pass.
Yeah.
Excuse me, sorry. We will pass the witness.
Thank you. Sir, my name is Mary Chartier. I've got some questions for you this morning. So following up on something that you said at the end, in response to a question about electors that could not be verified. Do you remember that very limited line of questioning?
I do.
Thank you. So isn't it fair to say that you absolutely could verify the electors from Michigan? Because you match it with the certificate of ascertainment, right?
Yes, the authentic certificates of votes, that's what we verified, that they were authentic and appropriate, and that all the language was appropriate, et cetera.
And so let's imagine you got a certificate of votes that listed names like Mickey Mouse and Donald Duck and George Clooney. You would know that that is not accurate because you verify it against the certificate of ascertainment, correct?
Correct?
So that paperwork is essentially meaningless, right?
I mean, it's not, we don't use it.
Correct.
And
So you don't use it in terms of casting any votes, correct?
When you say in terms of casting any votes, what are you referring to?
Sure. So if someone says electors voted for Donald Trump, but it doesn't match with the certificate of ascertainment, that has no effect on what is occurring, correct? In terms of who becomes the president of the United States.
Assuming that everybody trusts, that all the members of Congress trust the authenticity and don't rely on the fake certificate, then it would not, in the end, change the votes that were authentic.
Well, I didn't mean to cut you off. Were you done?
Sorry,
I think we've got a little delay going back and forth. I wanted to make sure I didn't cut you off. Are you done, sir?
I am.
So, but you had earlier testified that there are a number of ways that those votes are verified, right?
That's right.
You listed two, essentially. The certificate of votes is matched to the certificate of ascertainment, right?
Yes.
You said that everything happens very publicly, so you also have sort of public knowledge about what is going on in terms of voting, right?
Right.
Are there other ways that you can think of that you didn't already testify to?
That we validate that we are presenting valid. I can't think of any other ways off the top of my head. I don't know.
Okay. And the document that you said was received by the Senate, did you personally receive that?
What document? The fake electoral certificate or the authentic?
The Republican electors' certificate of votes.
I personally reviewed it, and it did come into my custody at some point. Yes.
When did it come?
That wasn't the first one.
When did it come into your custody and from who?
I think I would have received it. I think the Michigan one came in a little bit late, and so it was added to the collection of the other fake certificates. And I believe they came to me from the parliamentarian's office, or it might have been another staffer of the secretary's office who handled them before they came into my custody, before or after the counting of the ballots.
So you said it came in a little late. You don't know if it came in before or after?
No, it came to the Senate Mail Services on, I believe, January 5th, but it didn't get to me. I don't think it got to the President's office or the custody of the Secretary until I think the 7th.
January 7th?
Yeah, so it was in the custody of the Senate on the 5th, is my understanding, but it didn't reach my office until the 7th,
And you also said it
possibly
did,
the 8th,
oh, I'm sorry, beg your pardon?
or possibly the 8th.
And that
I don't
includes,
recall.
that includes reaching the president of the Senate as well?
It went to the office of the President of the Senate before it came to the office of the Secretary of the Senate.
Do you personally know when that was?
My understanding is that that was on the 7th.
On the 7th.
If
On
I recall
Jan-
correctly.
Now, the certificate of ascertainment we covered with another witness, you would agree that comes from an official state source, correct?
Yes.
And the certificate of votes has certain requirements that must be met on that certificate of votes, right?
Yeah.
And so, just a couple of those requirements are a state seal, it's got blue ink on fancy paper, you'd agree with me, right?
I don't remember the blue ink part, and the paper is up to the state. All the states use different forms of the certificate. That's the language we care about. The language is that all of the electors sign it and certify the 2 different lists as required by the Constitution, and then as required by federal law, they attach or they annex to it a copy of the certificate of ascertainment.
The certificate of votes you received from Republican electors, you'd agree there's no state seal on that, right?
Correct?
No one submitted a certificate of ascertainment, right?
I'm aware that one exists, that's correct.
Correct? And you'd agree with me that the document submitted to you is essentially, looks like it's typed on a word processor, right?
Well, as I said, we get certificates of vote looking in many different conditions, but the fact that it looks like it's typed on a word processor that would be meaningless.
Okay, but
But right,
but it doesn't have the state seal, so that's not meaningless, right?
that's right, that's right.
And it didn't have a certificate, oh, I'm sorry, sir, go ahead.
Oh, please.
And it didn't have a certificate of ascertainment, and that's not meaningless, right?
Correct.
Now, the document that you've been referencing, you have no idea what any of the signers were told before they affixed a signature to the signature page. You'd agree with me, right?
Yes, that's correct.
You don't even know what anyone saw before they signed their name to that signature page, correct?
Correct.
You don't know who sent the document into the Senate, right?
I think we have the envelope that would have a return address, but I have no idea.
Where anyone could write any return address on there, you would agree with me, right?
Correct.
So return address is essentially meaningless. That doesn't tell you who sent the document. Agreed?
Correct.
And you, other than receiving the document, you really don't know anything about its creation.
Correct.
And you also don't know anything about the intent of the individuals who affix their signature to a signature page, correct?
Right, other than what I can infer from the face of it, yes, I don't know anything more than that.
I'm not asking about what you can infer. I'm asking about, you were not present when signatures were affixed to a signature page, correct?
Certainly not.
And again, you weren't present when people may have been told or not told certain aspects about the document, correct?
Correct.
I have no additional questions, thank you.
Good morning, Mr. Schwager. My name is George Danini, and I represent Kathleen Burton in this case.
No.
I'm going to try not to cover the same ground. I just want to make sure I've got the timeline correct. So you said, I believe your testimony is that the Exhibit 14 was received in the Senate Mail Services on January 5th of 2021. Is that correct?
recollection and understanding, yes.
And then I believe you said it went to the President of the Senate on January 7th, 2021,
I think that's correct, yeah.
and that it came into your possession and your role as the General Counsel for the Secretary of the Senate on either January 7th or January 8th, 2021, right?
It could have been after that it came into my personal custody, but I believe it came into custody of the office of the secretary on the 7th or 8th, but I don't recall which day I think got it or it was brought to me.
Fair enough, but it's obvious that the counting of the electoral votes for the 2020 election occurred on January 6th, 2021, right?
6 and, it went into the 7th, but yes.
Fair, but both,
Started in-
yes, that's fair. And both before it came into either the Vice President of the Senate's office, or excuse me, the President of the Senate's office, or the Secretary of the Senate's office.
I'm sorry, what was before?
The receipt of Exhibit 14 occurred,
After the counting,
that's right.
received by the vice president, yeah, we did not have the mailroom express delivery that, as we did with other certificates. We were aware, I think, that it was within, but I don't think we asked them to bring it to us directly.
Okay, regardless, it wasn't available at the time of the count.
Oh, no, it was available
Not to you.
if asked for it. Well, no, we work regularly with mail services, and if we had needed it, expedited, if a senator, or a member of Congress or the vice president had asked for it, we could have gotten it expedited from the mailroom, yes.
Okay, you could have asked for it expedited if it was needed, but it wasn't needed, right?
No one asked us for that one in particular.
Because the
For any-
because that document had no legal significance whatsoever. Fair?
Not unless the senators or members of Congress have chosen to ask for it and take it into consideration in some way, and that didn't happen.
Let me ask you this: is it permissible under federal law for a state to submit two competing electoral votes, certificate of votes, with certificates of ascertainment?
Not under federal law, not to my understanding.
Are you aware of a situation in 1960 Hawaii where exactly that happened?
Yeah, I recall that there was some issue in that, and it had to be sorted out by Congress, if I recall correctly.
And that had to be sorted out after the electors voted on the statutorily required date. Fair?
Yeah, at this point, I haven't looked at that in a couple of years, so I don't remember the details of it.
Okay, and that's fair, and you're not here to really testify about that, but back to my question then, having reflected on 1960 Hawaii for a moment, it is permissible for a state to submit two certificate of votes with the certificate of ascertainments, and that would be sorted out by courts, Congress, etc. There are mechanisms in place to allow for this, correct?
Again, you're asking me what's permissible.
How about authorized under law?
Your Honor, I'd ask that the witness be allowed to answer the question.
That's fair. I thought he was done. You, sir, answer your question, and then I'll ask my follow-up.
Thank you. I don't know if there had been a ruling or there's been a determination that what happened in Hawaii was applicable or authorized by law. I understand it happened, but my reading of federal law is that there should be a count and there should be a certification of the count. And I don't understand the details of the Hawaii case, or don't recall the details of the Hawaii case enough to agree or disagree as to whether there was a finding of what is permissible or to characterize exactly what they did. If their governor and secretary of state find two different ones, I don't recall that, and I don't know the details of it, and I don't know what precedent or authority it holds today. That would certainly be different, from any group or any individual person. Yes. sending in a certificate to try to get considered.
Okay, let me ask you just a specific question. If you don't know, it's fine. Electoral Count Act, 3 U.S.C. Section 15. Are you aware that that allows a representative and a senator, as long as you have one of each, to object to the count on January 6, 2021? Here, January 6, 2021?
Absolutely.
What was that?
Absolutely.
Absolutely.
Yeah.
All right. I'm not going to go into this in detail, but obviously there are certain statutory requirements that require a certificate of votes to match up with a certificate of ascertainment, and you talked about the importance of that and how those things need to match up. Fair?
Yeah.
And that's to ensure that the votes coming from the states are the actual votes from the states, right?
Sure. It's an okay way to put it, yeah.
All right, and maybe not the most eloquent, but captures the gist, okay? All right, and you've got the Senate obviously involved, you've got the NARA, there's multiple checks and balances that are built into the process, okay, right?
Correct.
Okay, I don't want to focus on that. What I want to focus is on your quote, all of this happens out in the public. Do you remember saying that on direct examination?
Yes, I mean, what I meant by all of this, it doesn't mean every single conversation, every single step we take, but yeah, the announcement of the votes and the winners and, and who the governor and the secretary of state are certifying or ascertained, those things tend to happen in public, those big announcements.
Whoop, looks like you froze up. Are you there? Oh, there you go. So the this, yeah, I can hear you, sorry. The this is the presidential election, right?
Yes.
A very public affair.
Yes.
You've got all the news stations covering it.
Yes.
And it's no secret, there's all kinds of projections that go into it, but it's no secret who wins each and every state. Is that right?
It shouldn't be.
So in addition to all these checks and balances that exist for the documentation, we've got this very public election that's out there in the public domain that everybody can see, right?
That's right.
And so nobody's going to fool you as to who won the state of Michigan or the state of Mississippi or the state of, doesn't matter. You follow this pretty closely, and so do all the reps and all the senators, and of course Vice President Pence, who's in charge of counting the vote, who was involved in the election itself. Fair?
I would like to think that all those people you listed should clear on what the evidence is and what the results are.
And certainly you pay attention to it in your role as the general counsel for the Secretary of the Senate.
I do.
And Exhibit 14, which you didn't receive until a day or two after the official count, played no role and no significance in your job in that governmental function. Yes?
Not in my job,
Thank
but
you.
obviously there's
That's
a
all.
lot of
Thank you.
controversy.
Hello, Mr. Schwager. My name is Nicholas Somber, represent Ms. Sean Maddock.
Hello.
Hello. I want to ask, in your experience, how common is it to receive multiple submissions of delegates from any state?
I think it's not uncommon to get one or two often really wacky submissions from people claiming to be electors that are just, way out there. I think we get maybe one or two every 4 or 8 years or something, if I recall correctly.
Okay, and is there any, there's no legal significance to those documents, the wacky ones?
I mean, again, as long as Congress doesn't want to consider. I mean, my word is not the final word, but our office's word is not the final word. So, you know, what would give something legal significance is how it's used after us. But we would not present those. We would not be asked to present those, or have not been asked to present those as authentic certificates of vote. No.
Okay. And what do you mean real wacky ones? Can you elaborate on that?
You know, now that I've characterized it that way, it can get too specific or insulting, but, you know, there are individual citizens who claim some authority under some interpretation of the Constitution to cast an electoral vote, and they might send that to the President of the Senate.
Okay, and does the Senate have a precedent for how to handle such submissions?
It's same as many different submissions from citizens. They might be, you know, archived in the records of the Secretary of the Senate, and they might not.
Are they ever referred to any prosecutorial bodies?
I don't recall.
So, like you have received a document from somebody claiming to be an elector in the past. That's right. Is that correct?
I think I recall in some letter claiming to be able to cast the vote, not you know, purporting on it law or anything like that, but claiming some constitutional theory or something.
Sure.
If I recall correctly.
And that's my point. You've received in the past a letter from somebody claiming to have some authority to be an elector. Is that correct?
Yes, the Senate has received, not me personally.
Okay.
Yet.
And to your knowledge, a document like that has not been submitted to a prosecutor or attorney general.
I don't know. I don't know either way.
I have nothing further. Thank you.
Good morning, Mr. Schwager. I'm George Brown. I represent Marianne Henry. So you testified that you don't make the call on how these votes are handled, on whether or not they're counted, right?
Oh.
That determination is going to be made by Congress, correct?
Correct.
So isn't it true that, and you're aware what Exhibit 14 is, right? I know you don't have the numbers, but you remember Exhibit 14?
Oh. Yes, I do have the numbers on them now.
Isn't it true that Exhibit 14 received the exact same treatment that the other wacky electoral votes submitted that you testified about?
No, I think there was far more awareness of these than the other ones that were nearly identical to it, and there's a lot more questioning about.
Sir, I'm not asking if there was more awareness or questioning. I'm asking if they were treated the same.
Your Honor, I believe the witness was trying to answer the question I asked if he be allowed to finish his answer.
Yes, the witness can continue his answer. Mr. Schreiber, you can give your answer.
Okay.
I could ask it again. Isn't it true, sir? Isn't it true, sir, that the votes in Exhibit 14 were treated the exact same? Not that there was more awareness or discussion about them, but that they were treated under the law the same exact way as any other wacky submissions.
Under the law, or physically and logistically?
How they were treated.
Under the. That's correct. They were not. Sorry.
I'm sorry, I'm just trying to clarify because you did change the question when you asked under the law. So which one do you want him to answer?
I suppose both. Isn't it true that both under the law and generally, isn't it true that they were treated both the same way?
No. Generally, logistically, something that comes in from some random citizen that, you know, doesn't bear any of the hallmarks of something authentic would never, you know, even warrant attention or discussion or consideration, we wouldn't even know if it would be part of the same records or exactly how it would be archived. These were of a more serious nature than the ones that I was referring to. So I can't say that I can't say they're not handled in exactly the same way that others might. And legally, in the end, right, they were not considered by Congress, or they were not accepted by Congress. I don't recall if they were used in the debates of the two objections that were lodged. I wasn't present for all of the debates, and I have not heard the debates. I certainly wasn't present for any of the House debates. I was present for some of the Senate debates, but I don't recall if they were considered in those debates or not. And I also don't recall if they were, how they were used by the people who were protesting and if they were used as a basis.
Your Honor, I object. This seems to be a narrative, and all we're getting is, I don't know, I don't recall, I don't know, which then he shouldn't be testifying if he doesn't know or doesn't recall.
So it sounds like his answer is, I don't know.
I got an answer to that question, yes.
Okay. Objection sustained.
Mr. Schwager, how is it functionally that votes go from your office to Congress on the day that those votes are counted by Congress?
Prior to January 6th, they are, we ensure that we have a complete set of certificates of votes that are appropriate in their content, wording, and we place them in ceremonial ballot boxes that you might see, and those are in the custody of the Secretary of the Senate until the 6th, and then on the 6th, we deliver them to the Senate chamber. From the Senate chamber, they are carried to the House chamber for the joint session in those boxes to the extent they fit in those boxes. And then at that joint session, they are handed up from our staff up to the President of the Senate. The President of the Senate or Vice President hands them down to the tellers. Portions are read, or the results are read and announced. And then they are returned to our custody after the counting is completed.
And isn't it true for those documents to be placed into the ceremonial box that's sent into the chamber, there must be a certificate of ascertainment from the state?
Yes, we have not placed any ballots that were not accompanied by certificate of ascertainment in those ballot boxes. We have not handed them up to the Vice President if they did not.
And it would also have...
They did not.
Sorry.
They did not comply with that. Right.
And they would also have to appear at your office on time, correct?
Yes, but we actively ensure that we get them. We are in communication with the offices of Secretaries of State or the state election offices. If we have to, we'll call the governor's offices. That's part of what we do, and we partner with NARA on doing that, and it takes some effort. We ensure that we get an authentic document in proper form from every state before the 6th.
No further questions, Your
You had indicated that you received a false slate of electors from other states, is that correct, in the 2020 election?
Yes.
Which states were those?
Best of my recollection, in addition to Michigan, there was, I might get some of this wrong, I might not remember everyone, but I think it was Arizona, Nevada, New Mexico, Pennsylvania, Georgia, and I think Wisconsin. That's my best recollection.
Ms. Shorty asked you a question, and I'll paraphrase it, that basically if you got a slate of electors that listed cartoon characters, you'd know that it was patently false, correct? Okay, and she followed up that question with something about submitting it to the Congress, and you indicated you weren't sure what Congress would do. Why did you say that?
Well, just because I am not the final arbiter of what the senators and members of the House of Representatives choose to do with anything. you know, I'm not the one who advises them. The parliamentarians of the two chambers advise them on if they have questions of precedent and rules and the law, and they also, you know, consult and decide for themselves. I only meant to say that, you know, I am not a final authority, nor is the secretary in Congress.
But you do advise Congress, don't you?
I advise the secretary, the parliamentarian advises Congress. I work with the parliamentarian, but I don't typically advise senators on questions of rule or law, unless on a rare occasion I might be asked. But
Would you agree that notwithstanding your comment about not understanding what Congress would do, in fact, for all those other states that submitted false electors, Congress did not accept any of them, did they?
again, in the end, the
It's
objections.
just yes or no. Congress did not accept any false slate electors from any of the states, did they?
Correct. There were no objections to Frank. That's correct.
Did you get requests for any of the false legislates from Michigan?
I'm sorry?
Did anyone request that the false legislate be sent to them? Anyone in Congress?
I don't know, not me personally, but it would not have come.
Well, that would have been extraordinary. That would have been extraordinary, and you probably would have remembered that, wouldn't you?
If someone asked me, I certainly would. I mean, I am aware that there were discussions of those electors, of those late. But I don't recall if we were asked to give copies, and in fact, I think the recollection is that people had copies of them aside from us.
You cited by name particular states. Are you involved in criminal litigation as a witness in any of those other states?
Objection, Your Honor, relevance.
What's the relevance?
If there are other states in this litigation, then he's been testimony. He made testimony on this very in that. I think we were entitled to it.
What's the relevance in this case if you made testimony in another case? If you did, you can go get it.
He has both, well,
It has
yeah,
nothing to do with this case.
you're right, I can go get it if I know what states there are.
Yeah, but what does it got to do with this case?
I'll withdraw.
Thank you. Objection sustained.
Thank you.
Any further cross? Redirect?
No, Your Honor.
Oh, thank you. And may this witness be excused.
Yes, please.
Okay, Mr. Schreiber, there is a sequestration order, so you're not to discuss your testimony with any other witnesses in this case, okay?
Yes.
Thank you.
Yes, Your Honor.
You can be excused.
Thank you.
Thank you. And it's 11:51, so we're going to recess for lunch. Let's see, we have Ms. Lundgren here. She'll remain on the Zoom. We'll keep her muted. And then I'm going to mute the courtroom while we're away. And then we should be back here by 12:30. Give me 12:45. I got to do a search.
Michelle, did you hear that you're gonna remain on Zoom, but we're officially, okay?
Ms. Lundgren, can you hear us? I'm not.
Yes, okay. So you can't discuss the testimony you've heard with Carl, but you can interact with Carl, your husband, and to the extent, I know you don't get around much, to the extent that you can, you're basically on your own time, but need to resume. What time is it again,
We're gonna come back at 12:45.
You need to be prepared to listen to testimony again, no later than 12:45.
I'm Frank, but trying so hard. Okay.
Almost 4 years now, I get it, but